very astute observation, and which, as I stated, that sentiment guided our testimony here before you today.
Thank you, Mr. Chair.
Thank you. Just to follow up, and then Senator Block had a question. The issue of having the attorney present during the board meetings and hearings and making that decision, I guess the concern that I would have with that in looking at it is the authority is too deflected. The authority is not clear in one person that can be overseeing all of those in your office or some other office that makes those reviews. It's kind of a little too vague, I guess, and not quite as secure. I mean, that's just as I'm hearing it today. Senator Block, and then I have a couple other questions.
Yeah, thank you, Mr. Chair. Just want to make an observation. I'm glad to see USD is here, because to me, this really, all the many boards and other types of entities you oversee are really all about consumer protection. Correct. And to the extent that a regulation may restrain trade, but has a clear consumer protection goal and, in fact, outcome, then I would assume that would outweigh the restraint of trade provision. For example, if we found that teeth whitening, in fact, resulted in thousands of North Carolinians being severely damaged if it's not done by dentists, then would there be a difference in the outcome of a court decision? And if so, then is it more really fact-based and evidence-based than it is just what the content of a particular regulation is? Really, is that regulation primarily for the purpose of protecting the public, or is it primarily for the purpose of restraining trade?
I definitely locked on to a statement that you said, which I could not agree more, of fact-based and evidence-based, which is why the department, with the help of the Attorney General's office and the Governor's office, came out as early as possible to train. We truly believe that the best way to mitigate this, not the only, the best way to mitigate this is a well-trained, well-informed board. You know, board members individually, board as a whole, and to document and memorialize the decisions they make and why they make it. As things come up, and they will, you know, the best way to mitigate that is to have public records, to go on record saying, this is why we made this decision, have proper minutes, all of which my colleague to my right mentioned. We've taken those steps. Everything after that, you know, is ripe for discussion, but a well-informed, well-educated board that serves exactly what you said, the consumers, is the best, in my opinion, the best defense.
Okay, so it's clearly a restraint to trade to say that you have to have a medical license to practice medicine, because it would certainly be more competitive if everybody could practice medicine. So it restrains trade, but there is a rationale that clearly protects the public, so that's a restraint of trade that's acceptable.
Absolutely.
And I guess that balance is what we would have in many of these cases.
Well, you know, the decision in that case, a board that regulates doctors would make the decision. If you do not meet these qualifications, then, you know, you are not a doctor. The thought process to get there is in the best interest of the consumers, and it is documented, and it is clear that, you know, that body is not acting in the interest of, you know, any one person or an association, et cetera. They are doing this, setting minimum competency or minimum qualifications because it is in the best interest of the consumers. So that is exactly, again, going back to training, going back to memorializing why boards opine and make these decisions is extraordinarily important.
Thank you.
Absolutely.
You've mentioned a couple times, Mr. Director, that the documentation and the record, and I think we all, agree that that's an important determinant as to what's the basis of the decision, how you got there, what the consumer protection value is, and everything else. But I also know that your many boards that you have, they're not necessarily consistent in their minute keeping, minute taking. So some are webcasted, some aren't. The ones that aren't are sometimes don't have very good records. So what steps have you taken to kind of create some consistency, some accuracy, and some documentation that could withstand a challenge at some point in time?
One of the biggest steps that we've taken shortly after the North Carolina ruling was the training. And I'll defer to my colleague to get into the details of kind of what type of record keeping, et cetera. But the training that we had, it was on the 21st, correct? Also folding some of that training into the board member orientation. We call it BMOT. Refreshers, are always a good thing. There are things that are lost after you're reappointed. We want to make sure, given how important this is, we felt it important to put it into the board member orientation training to make sure that it's always on the forefront of people's mind as they make a decision, whether they feel it's important or not. It is important to go on record and be in the most defensible position possible. I'll yield my time to Ms. Colson.
Okay, thank you. We have encouraged the boards that the record keeping is very important in this area, and as you indicated, some of our boards do webcast, and those are kept for sometimes several years, so we have that documentation. Additionally, it's important that the boards have these discussions, and they do it in their open meetings so that the public can attend, and that we've encouraged them, at least in this area, to make sure that they are keeping records of not just the decision, but that their minutes reflect the pro-competitive and anti-competitive discussion, which the public policy discussion is a part of. So we have been suggesting to them that the record keeping in this area ought to comport with the recommendations of the AG.
Well, and doesn't that lead to the consistency of the record keeping, so that is there an established department rule, requirement, or process, procedure, or in terms of minute taking, what details at what level? I mean, we've seen action minutes in some cases, and then there's the actual conversation, or is there, in the issue of webcasting, which I think is probably the best record of, I mean, you can certainly learn a lot and have a lot, and I think, how many boards do webcast? I don't know, but do you know how many there are, Mr. Jones?
I think they all webcast at various times. It's not a number of, 4 don't webcast, 35 do webcast, or 20.
Do any have policies against webcasting, or have not taken or made a decision not to webcast?
There have been those that have been more receptive to webcasting, and given limited resources, from the department, and webcasting takes a lot of effort from the department. We fly staff down, but there are some that are more receptive and than others. But webcasting, in general, is a push from the department that we're, if there's something on the agenda, whether it's important or not, we want to make sure it's as transparent as possible.
And I just think for the concern of access, I mean, it's a large state, and obviously the hearings and the meetings are in one location, and there are people 450 miles or 500 miles away that would love to be able to see exactly what's going on. So I would encourage all of the boards to, and maybe with your leadership, and could promote that in some way. Do you, there's another question I had in terms of, I know, you talked about your authority currently related to review of all of the actions of the different boards. How many times or how often maybe in the last 10 years have you exercised that authority to veto or overturn a decision that they've made or change it in some way?
None. I mean, and I think that is a benefit that I have not had to, and it speaks to the current structure working. There have been a time when my authority was expressed and the interested parties came to the table and revised the policy such that it was more palatable to the department. That was a anomaly, and so for the most part, the boards work very closely with the department. If there are any problems with any said policy, they know early, through the process, whether it's from my legal division, my ledge division, or myself personally, I'll call. I'm not shy about, picking up the phone and expressing how I feel about things.
You think, and obviously based on the North Carolina decision, you'll be looking at this through a different lens, and the anti-competitiveness issue is something that you would now be more focused on, I would think.
I think I will, given the importance of it and how it affected entities nationwide, it will definitely be a much more critical filter. I think my current authority definitely covers that, and the way I view it is injurious to my current authority, which is I'm able to reject based on regulations being injurious to the public. That is, we've had a loose interpretation of that even before the North Carolina. So I don't know if anything will change, but I will have a heightened filter by which I look at this henceforth.
Any other questions? No. Seeing none? Very good. Thank you very much. Mr. Director, thank you for being here today. And
Thank you so much.
Really appreciate it. And
Good to see you.
Ms. McLean and Ms. Colson, thank you very much. Mr. Howard, didn't have to call your name. You knew. From the University of San Diego School of Law's Center for Public Interest Law.
Mr. Chairman, Mr. Vice Chairman, members, thank you. Ed Howard, Senior Counsel of the Center for Public Interest Law, and thank you so much for calling this important hearing. I think I'd like to structure my remarks by first talking about where we might disagree with the Attorney General's remarks, and second by echoing some of the Attorney General's remarks. And I think starting off on where we depart from them, I want to pivot off Senator Bloch's really excellent and I think framing question. Senator, you asked about the fact that there may be activities that these boards want to engage in that in fact are pro-consumer and not truly anti-competitive at all. That's exactly why this needs to be addressed swiftly and comprehensively. Because if you think about the practice of medicine, for example, incompetently practiced, the practice of medicine can kill or hurt your family members. When you think about accounting or bookkeeping, an audit incompetently done by someone who is not a licensee or not ethically trained in audits can result in financial ruin and the elimination of legacies worth of and generations worth of savings and investment. So if making sure that our licensed professions are practiced only by those who are ethical, competent, and well qualified is one of the most important and basic functions of state government, and it is, and if our licensing boards are risk averse in terms of being proactive frequently in protecting consumers, and they are. Senator Wieckowski has asked some questions about the role of counsel at these hearings, or at these board meetings. Having been to dozens and dozens and dozens of them, I can tell you they are very risk averse, as are their counsel. Just as any good lawyer goes out of their way to try and caution his or her client that if they do something they might get sued, as a functional matter, when you go to these licensing board meetings and the Department of Consumer Affairs counsel says, if you do this, you might get sued, that ends it. That ends it. So if our licensing boards are already very risk averse in acting swiftly and comprehensively to protect consumers, and they are, then the current state of affairs, where board members potentially individually, as well as the state treasury, could be liable for many, many millions of dollars simply because they choose, Senator Bloch, vigorously to uproot unlicensed, dangerous practice. That is a really big deal. And in a state which is afflicted with drought and fire, it's hard to say that that's a crisis. But it is a very, very big deal. It is very important that this legislature and the executive branch move swiftly and comprehensively to remove that disincentive from our licensing boards from swiftly and effectively acting and ambitiously acting to reduce unlicensed practice. This is not theoretical. This is not theoretical. Just yesterday, the Veterinary Board removed from its agenda proposed regulations mandating that animal rehabilitation be done under the supervision of licensed veterinarians. And in part, they removed it from the agenda because they were worried about getting sued. Now, we take no position on whether or not that's a good or bad regulation, but we do take a position on this. Getting sued for antitrust liability ought never be a consideration for these boards. It ought only to be purely public protection. And so long as the current state of affairs exists, where we have not definitively and effectively removed antitrust liability that could, according to the Attorney General's opinion, could potentially visit upon the individual board members, we're not going to have an effective licensing program in this state. So it may not be a crisis, but it's a really big deal, and it's already happening. That's where we part ways with the Attorney General. Where we agree with the Attorney General and with Director Kidane and his staff is that relatively modest steps tweaking the architecture of current state government are sufficient, we think, to remove even the potential of antitrust liability affecting board regulatory ambitions. Now, we see there being two buckets of proposals. Everyone has mentioned so far what we think is simply the easiest, and that is having a supermajority of eliminating the active market participants from being able to dictate policy in the state of California, and creating instead licensing boards that have a supermajority of public members. I want to emphasize nobody, including CPIL, is talking about eliminating the ability of brain surgeons to have a say in how brain surgery is regulated. But what's real clear from the North Carolina case is that brain surgeons can't have final say entirely on how brain surgery is regulated. So the simplest thing to do that doesn't require any new bureaucracy, doesn't require any new hires, doesn't require any new expenditures, not a single appropriation has to be made, is to simply change the compositions of the boards to make sure that they have a supermajority of public members. It is true, as the Attorney General mentioned, that we do not have a pegged number about how many or how few public members would completely insulate a board from antitrust liability. The FTC guidance mentions exclusively public members. But we believe at the center, and especially Professor Felmuth, who's a recognized expert in antitrust law, that a supermajority would be ample to insulate the boards from any risk of antitrust liability. So that's the simplest, easiest, and the least expensive one. The more, but assuming for the sake of argument that the legislature elects not to pursue that route, there is another option which tracks to some degree some of the options that you've heard thrown out by the Attorney General and the department. Our proposal is relatively straightforward and simple. The first is you've heard reference to the statute that allows the director of the department to veto regulations. That statute has to be amended, and it has to be amended to eliminate the exemption from that veto, which is for licensing examinations. And the second way that it needs to be amended is that the unanimous vote of any licensing board that has a professional member majority can no longer overcome the director's veto. Relatively simple. This is 3 or 4 lines of stricken code. The second is to require the Office of Administrative Law to review regulatory packages for anti-competitive impact. One place where we substantively disagree with the Attorney General is the Attorney General mentions that the current regulatory regime over there at the office is sufficient to cover that. Respectfully, no, it isn't. The office's charge for how to review regulations is specifically set out in code, and the Professors Felmuth will berate me for not knowing them by memory, but there are 6 of them, and one of them is not whether or not regulations are anti-competitive. So the Office of Administrative Law currently doesn't have explicit statutory authority to engage in that kind of required analysis under the North Carolina case. We think they should have it. That's adding one sentence to the list of Office of Administrative Law required reviews that would be helpful here. But more deeply, and Senator Wieckowski, this I think goes to some of your questions about what would and would not qualify for state supervision. What's real clear from the Supreme Court decision and its antecedents is that the Supreme Court, for example, says it can't be merely theoretical supervision, quote unquote. That, and the background paper, I think, pulls this out correctly. The power of the non-interested, the uninterested, non-professional supervisor has to be to review the actual substance of a law. So public comment, for example, wouldn't count. Advice of counsel wouldn't count because they're giving advice. They don't have final say. But to review the substance and to be able to veto it and modify it, in the words of the court, so that there is, quote, independent judgment and control by somebody who is not a market participant. You need to have a boss. You need to have somebody who's not a market participant who's a boss who can say yes, no, or change that. We think that the best place for that is the Office of Administrative Law. And what that means is that it's not just a review of anti-competitive statements by a regulatory agency. We know, and I think my recollection, Vice Chairman Jones, is that we've had colloquies about this in BNP on government reform issues. Very frequently, these statements that you see in regulatory packages about business impact, for example, which currently OAL requires, they're very cursory. They're really not meaningful or substantive as they should be. Now, that may or may not be good policy here in California, but when it comes to insulating the state from antitrust liability, we have to make sure that it's meaningful. And so our additional proposal is that when the Office of Administrative Law is reviewing regulations for anti-competitive effect, they have to have expert advice, expert economist advice. And that doesn't have to be a full-time person. The medical board, for example, and the other boards frequently on an ad hoc basis engage experts to take a look-see and render an opinion about whether or not something violates a standard of care. But there does need to be, we think, in order to satisfy state supervision, a truly meaningful bona fide review of the regulations that isn't satisfied just by writing it on a piece of paper and sending it to someone who isn't qualified. And we can infer that this drive for substance over form, Senator Wieckowski, going to another question that you had asked about whether or not a bare public majority of one might work. Well, the court's real clear that it might not. There's a quote that I pulled out, which is, active market participants need not constitute a numerical majority in order to trigger the requirement of active supervision. What the courts look at is what's constructively happening on the ground. And for those of us who spent a decent part of our finite existence in licensing land and looking at these boards, it is in fact practically very common that public members will defer to the professional ones. And the court actually talks about that as being instrumental in its decision as to whether or not there's really truly active state supervision. So it has to be real. It can't just be superficial or papered. And for that reason, we think that wherever this supervision has to take place, it must take place with the advice of an expert in anti-competition to make sure that it's true and meaningful in order to come all the way back to Senator Block's question, in order to accomplish the aim here, and that is, here's the aim. When a licensing board turns to their counsel in thinking about something that addresses unlicensed practice that may harm consumers, we want them to be able to turn their DCA counsel and have their DCA counsel say, no, because of legislation enacted in 2016, you have no fear that whatever disciplinary matter that you're going to pursue or whatever regulation you promulgate, are you going to get sued? That's what we want at the end of the day. Trying to think. Oh, and then finally, that takes care of what the Attorney General called the quasi-legislative piece, the regulatory piece, but there is still the piece that actually gave rise to the North Carolina decision, and that is discipline. And we agree with, and forgive me, I forget who asked the question, but one of y'all asked the question, I think of the AG, about whether or not, oh, it was you, Mr. Chairman, asked the question about whether every individual decision had to go up and back and up and back. We agree that the answer to that is no, and in addition, that would be itself very chilling on good regulatory behavior. What we propose instead is that within the Office of Administrative Law, since you're going to have this expertise anyway, provide a place where licensees can go and complain about a, quote, pattern and practice of anti-competitive conduct against non-licensees. We think that or very confident that that ability to complain and have decisions acted upon by that neutral office would, we think, satisfy that prong of the North Carolina case that deals with whether or not discipline is being meted out in an anti-competitive way. But I want to emphasize that educating board members, as excellent as that is, educating DCA counsel, public comment, none of those things are sufficient to be able to give confidence to these DCA boards that they will not get sued, Senator Block, for doing the right thing, and that's our biggest concern. I'll conclude, and I'm pleased to answer any questions you may have, with some 1,000-foot thought about the North Carolina case. Nobody, I think, here would author a bill that would would replace the elected insurance commissioner with a panel or commission of insurance company executives that would instead run the Department of Insurance. Nobody, I think, here would propose a rejiggering of the Public Utilities Commission that would give a majority of votes to utility company executives. Nobody here would probably support or even imagine that there could be a regulation of lawyers which would have a 2-to-1 professional majority, and actually where some of the regulators were elected by lawyers. Oh, I forget now that we actually do have that, I'm sorry. The point is that the day when we let the regulated do the regulating is over. This is a legacy of medieval guilds. And the time when we allow the people who are regulated to have final say over how their professions are overseen has to come to an end. And it needs to come to an end quickly in order to ensure, at minimum, that our licensing boards are not placed between the rock and the hard place of doing their jobs and potentially getting sued. And with that, I'm pleased to answer any questions you might have.
Thank you, Mr. Howard. Questions?
Yeah, it's interesting, Mr. Chair, that when you focus on the risk aversion that the boards have right now, if when I put the anti-competitiveness and antitrust potential Sherman Act violations, I feel pretty confident that they're not going to do anything because they're so risk adverse. Even thinking that they could be indemnified. If before North Carolina Dental, that the California system is set up, which is a different goal, because we're here worried about Sherman Act, which is a different goal than I want these people to be more consumer advocates. That's a worthy goal. That's a worthy goal, but not evidently the problem that we're trying to address here, because that's, well, it is a worthy goal. So, and I don't know if we need to have complete insulation. You're suggesting that we need completely insulate these board members from any action that they may take is the remedy. Because if we did nothing, if I just listened to the first half of your testimony, if we did nothing, I would walk away and say, well, I think we're pretty safe.
So,
I mean, I see there's a different goal of trying to have the boards be more consumer oriented.
the problem is that, I understand your point. The problem is that even frivolous lawsuits can be brought and threatened. And I suppose I think of the formula this way. If you think of the fact that absent clear statutory authorization to go after a particular kind of unlicensed practice, which all by itself would insulate a board from liability, right? We're talking in this sort of brackish area where there isn't a statutory edict that says you can't do teeth whitening. If there had been a statute that said that in North Carolina, we would be done. There would have been no liability. So what we're talking about is a place where a licensing board, exercising its inherent discretion as to what is and is not its scope of practice, elects, hopefully pursuant to a public protection reason, to go out and try and do the right thing. The problem is that it's not always going to be incredibly clear, incredibly 100%, no one even threatens to sue you kind of clear, that when they're pursuing public protection, they're not actually acting in an anti-competitive way. Surely, whether it's when you hear boards now go after unlicensed practice, the cry always comes up from the people being charged, you're only doing this to protect your turf. So the problem here is assuming that somebody might have a good faith basis to say that an action being taken has a truly anti-competitive motive. If there's even a scintilla of the ability to be able to do that, Senator, and they threaten a lawsuit, combined with the inherent risk aversion of, frankly, all of government, but government lawyering, especially in this context, what you will see if you don't offer complete insulation, complete coverage to these board members is risk aversion. You see it all the time now. I am, for CPIL, constantly in the business of attempting to persuade licensing boards to not have to come to this legislature every time they want to do something.